Peace, peace. Welcome back, Flesh Fam. The God Shango here once again, dropping some serious legal bombs in the fight for justice. Today, we're diving deep into a situation that just got a little bit deeper. So buckle up for the latest in the YSL trial rabbit hole.
Ms.love and Ms. Hylton and Mr. Atkins, who is going to be called? Let's assume that Mr. Copeland invokes again. Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland, and there are certain things that have to take place before we can tell them anything. So
okay.
we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay.
So, there's been some concerns about Judge Glanville, aka Judge Bias, and his involvement with the case. Remember that whole ex parte meeting situation and the contempt charges? Yeah, that wasn't a good look. A fair trial ain't exactly fair if the judge ain't impartial, right?
But however, there's nothing that I can, service, remember we had this conversation before, you have got to get service. Services puts me on notice that you filed a lawsuit against me. So you just can't kind of ignore that step and then kind of jump to the other things that are in the case. So and that also kind of is fundamentally fair. I mean, you wouldn't want somebody to sue you and then say, okay, well, I never tried to reach Mr. Jones or serve him with a copy of the lawsuit, but I want all this money or relief or other things. So that's what serving the lawsuit does. It puts the person on notice saying, hey, there's a lawsuit and you need to file an answer. You need to be, so that's why in this particular case, I haven't gotten any of those issues because service is so fundamentally important, okay?
Well, family, the plot thickens like a witch's cauldron. The court just dropped the bombshell. Judge Glanville has been recused from the case. But here's the thing, this recusal could seriously impact the timeline of the trial. A new judge has been assigned, but of course, as we know, it's gonna be a wave of emotions hitting her as soon as she stepped foot into them chambers.
Shout out to that cartoon over the weekend.
Said things that weren't true. Oh, shout out to Kayla. That was good. That was good. That was good, Kayla. That was really good. No.
All right, let's go to the next one. Motion to be relieved or withdraw as counsel. What type of motion is this? This is the motion that Kayla...
So shout out to AV. This is some charts showing the judge's history. The new judge, Shukura. This is some of her history. I'm gonna let AV run through it real quick. Just a little clip to explain a little bit about some of this judge history. What up, tall guys? I see you. Shout out for being here. Appreciate you.
Needed. This is what Kayla needed. This is when Woody was like, you fired. And it is likely that Judge Ingram would have granted that, okay? She would have not kept Kayla around. She would have let her go back to Houston. She would have not held this woman in court. So I think in retrospect, this is a little funny looking at this. She has 2.4% higher than the county's average of 87%. So look at that, 90%, she grants these 90% of the time, right? So if somebody fires their lawyer, we would go from there. Next, we have Fulton County's average at 87%. We have Georgia's average of 88%, right? So she's much higher than these two on the side here. And look, when we get that filed by the defendant, it's 5% higher when the defendant is a moving party. So look at that. If little Woody was in front of her and said, she fired, I want to relieve her from this case, it is likely that she would have granted that motion. So interesting. Okay, this next type of motion, and this is where the plot thickens, is this one. How does she do with motions to dismiss? She's 22% higher than the county's average rate of 80%. So where does she fall? If someone wants to file a motion to dismiss, she falls at 81% granted, right? The Fulton County average is 80%, and the state of Georgia is 81%. So she's just, she's slightly on par with everyone. But let's see what the numbers look like for defendants. So for defendants, the grant rate is 22% lower when the defendant is a moving party. See this line on the outside? We're going to see how she does with that.
I just got to do what I got to do. All right, Mr. Sato, anything, sir?
No, Your Honor, thank you.
Okay, all right. Here's where the court's kind of, where I think all of you are kind of stuck.
So this is some earlier stuff showing he been biased. This is when he denied Gunna's bond and the people walked out on the courtroom. This is before the trial even started, but he been on one. And this is just showing that it's way deeper than we all think, fam. Appreciate y'all for being here. Hit the like, hit the subscribe, tap in.
Between. There is the standard for bond, which is a preponderance of the evidence. And then there is, and that proffers are authorized by our state Supreme Court for bond. They are not offered or not authorized unless otherwise agreed to for trial. And that strict burden or strict proof is required for that particular proffer as a result to a issue of proof at trial. So we're stuck in between the two burdens in this case. We also acknowledge the fact that, you know, the defendants are presumed to be innocent, and this particular system authorizes the court to consider bond based on statute as well as case law, and and I have done so in this particular case, and will continue to do so. The other challenge that our imperfect system kind of just hasn't figured out a way to kind of deal with, other than reconsidering the issue of bond and changing circumstances of bond, is acknowledged for proof that may or may not come at trial, but the state bears that burden at this point in time. And it's not a perfect system in the sense that we won't know until that time whether or not many of these statements that have been proffered by the state come to pass or come to fruition. That's no consultation or consolation for your client, Mr. Samuel and Mr. Sadow. And but unfortunately, that's the best that the system can offer at this point in time, given the status of the case law and the like. The only thing I can potentially do is, like I said, I will try the case as expeditiously as possible. But at this point in time, I don't find any change in circumstances that would allow me to, or move me from changing my decision as to bond. And if anybody's in the gallery and you can't otherwise control yourself, or otherwise you want to make any appropriate comments, then you can leave at this point in time. No harm will come, or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
These two ants are so rude.
You need to get me off the camera and you need to step away from this
These
counter.
two ants are so rude. They peasants. They saying they manager on the way. I don't want to talk to the manager. Y'all ants.
Step away from this counter.
Your manager peasant. Y'all ants. Hold on. I give y'all bum man hold $15,000 a piece to quit your job. Willing. I'm giving you bums one more chance. Get their hair. Sink in on the hair. They have that. They look like Africans. They done got deported over.
Wow.
Yeah, this is horrible, you
Aggressive.
guys. So I actually spoke to...
This case involved defendants Fleetwood, Eppinger, and Beebe.
Yes, I believe they did.
Your Honor, if I may admit them for the purposes of this hearing, States Exhibit 3, 4, and 5.
All right, Mr. Fleetwood's counsel, any objection?
All right, you hear him, Mr. Fleetwood's counsel, right? So Mr. Fleetwood ain't got no counsel. They supposed to appoint him a counsel. But watch how they do him real quick. Or tried to do him, but they got caught.
Again, sir.
Oh, okay. Mr. Fleetwood, do you have any objections, sir?
No, sir.
All right. Mr. Eppinger, you have any? Mr. Eppinger, or your counsel, do you have any objections?
No objection for the purposes of this hearing.
All right. And Mr. Beebe's counsel?
No objection for this hearing, Your Honor.
Okay. All right.
Your Honor, Sean Hoover, in regards to Mr. Fleetwood, it has to be shown that Mr. Fleetwood does not have an attorney. He does not have legal representation, and he's not prepared to answer any of those questions.
Well, you're not representing him, remember, okay? He has the right, since he's self-represented, since no counsel has been appointed, he certainly can speak up for himself if he wishes to do so. I provide him, or anybody else who doesn't have counsel with that particular same ability. I understand that He does not have an attorney as of yet, but you know that's just the way we are at this point in time. So when you get him an attorney, if that attorney wishes to reevaluate anything that has been presented thus far, that person can do so and file particularized motions or any other issues at that point in time.
Yes, Your Honor, and I just want to make sure it's clear on the record that all these questions that be asked him, he does not have legal representation.
I understand that, sir, and I'll understand. I'll say for the record, he is not represented by counsel as of yet because we haven't been able to appoint him counsel, and that we have been attempting to do so since May of this year.
Right.
All right. All right, Mr. Fleetwood, did you have a question, sir?
Sir, I don't want to talk without my attorney because I ain't even.
Okay, that's all right. That's all right. You're good. Like I said, when an attorney's appointed to represent you, sir, you will then your attorney can go ahead and particularize or object to anything that's been done so far. Okay.
It's on Your Honor. I ain't even had a chance to get an attorney on my case. I've been on 24-hour lockdown.
You told me that the last couple times you've been here, Mr. Hoover. Okay, well, Mr. Hoover's working on getting you an attorney at this point in time, but you don't need to say anything else, okay? All right. Madam.
That's all I have on move.
Okay, all right, then.
All right, I know everybody been hearing UnFoonk name. He was just in that video. I don't know if you seen him in the bottom corner. I might run it back real quick just so you can see. And that was cold how they did him, but this is brother. All right, y'all can run it back. Anyway, that was him in the bottom left corner. Y'all can see him right here so y'all know what he looked like. But this is Young Thug's brother, his older brother, who they sent back to jail on some same bullshit. I don't know if he had a gun or not, but they say he did.
All right, you remember you signed, I want you to turn all the way to the end. It's on page 34.
Facts at Tall Glass real quick. She said once he starts stuttering, he's lying. Exactly. You could tell when he be lying or trying to come up with some shit because he also start fumbling. And you can see it in this video too. You're going to see sometimes. I think he about to do it right now and start fumbling. Or no, he did it earlier in the one with when they walked out the courtroom. If you watch that part, he was fumbling and trying to touch the papers. And he always do that when he start lying or when he on some bullshit. Hit the like and subscribe. Tap in.
It's dated December the 12th of 2022. It is, the title of it is Office of the Fulton County District Attorney, Atlanta Judicial Circuit. And it's got 1, current charges, 2, negotiated sentence, 3, special conditions of probation, 4, defendant's acknowledgments. And it's your plea agreement. You understand that?
Yes, Your Honor.
Okay, I want you to turn to that. I want you to take a look at paragraph number 2, negotiated sentence. B, in that particular paragraph. What does that say?
Defendant should possess no gun during the term of the sentence and the other after should be restored.
Defendant shall possess no guns during the term of the sentence or at any time thereafter unless his right to do is restored. Is that correct?
Yes, Your Honor.
All right. And your signature is on page 37. Is that correct? That you've read this agreement, you've had an opportunity to speak to Mr. Russ, Ms. Norman about this agreement, and no other promises other than the ones made in the document in furtherance of this agreement. And you gave this freely, voluntarily entered into this agreement without force, threat, or coercion. Is that correct?
Yes, Your Honor.
All right. So it's not like we didn't have a conversation about this firearm, right?
Yes, Your Honor.
So, as I mentioned earlier, I don't take pleasure in sending people to prison. It's part of the job and the responsibilities I have as part of what potential consequences are of people's actions. But in this particular circumstance, the state has alleged that you didn't pay your probation fees, and okay, and I've heard evidence that you haven't paid your fees. You owe $141.08 in fees. You haven't started any of the community service in this particular case. So I find those to be proven violations. But, you know, those are relatively minor. I mean, we still want you to adhere to all the conditions, but they're of the 3 violations and the grade of those violations, they're not as severe as getting a new case, okay? A new charge. And part of the special condition was that you're not supposed to possess a gun. And the state was very clear, and in Ms. Pretty testified earlier about the things that you were given in terms of your reporting in states 1 and 2. And then Ms. Goodacre came in and specifically you signed acknowledgement of firearm in states 3 and prohibition of possessing firearms or ammunition in states 4. And then I saw states 6 and 7, which was the Glock 9 that was taken from the vehicle, which you were the driver, shaded 3 to 4 inches from that. So I find that based upon the evidence.
So they didn't say it was his gun, but it was in the vehicle that he was driving. So somebody else could have threw it, but he didn't snitch on him. So now he got to go back to jail for 9 years.
Evidence presented in this case, the state has proven by a preponderance of the evidence that you have violated your probation in the 3 means as set forth in paragraph 4 on the petition. Now, in terms of the revocation, your attorney has asked me to consider a revocation of 2 years. And I certainly respect her, and I certainly respect that, you know, you don't know unless you ask. The issue I find aggravating in this particular circumstances are several. You got arrested with a gun within 6 months of you being placed on probation. And I agree with the state that you're not a candidate for probation because all you had to do is just complete your probation and do what you're supposed to do. Instead, you were riding around the car with a gun in violation of your probation and what this court explicitly had conversations with you about. Explicitly. On the record. And for that reason, sir, I'm going to revoke the balance of 9 years and 6 months. And you will serve that in the Department of Corrections. And that will be the sentence of the court. Anything further? No, Your Honor. All right, that'll be the sentence of the court.
Yeah, that's Young Thug brother UnFoonk. We're also curious to see how this plays out for the prosecution and Young Thug's defense strategy. This whole situation just got a whole lot more unpredictable.
So, if I may ask, are you in receipt of the communications?
I have, there's a lot of stuff you filed, but sir, I haven't specifically dug into all that because I'm looking for a service document to begin with. I have to be able to show their service. That's why I asked Mr. Kearns, do we have anything for service? Once we determine that issue, then I can look at the rest of the documents that you have.
Okay, is Mr. Kearns in receipt of communications?
Mr. Kearns is my staff attorney, okay? He's not the clerk, okay? He's not any of the other parties. He works for me, all right? But that's not the issue in this case. We told you just a second ago, we have a lot of documents. You were kind enough to include us as a service copy on those particular documents you filed. But again, to my original point, would you like to be given an opportunity to see if you can get service on?
So this dude is trying to sue him, right? And he's trying to get the notice to him that he's suing them, but they refusing the service, and they won't give him a court date because he ain't got the service. But the sheriff is telling them that they won't accept it. So what do you do? How do you sue when a judge is doing you wrong? Like they've been doing this. So just watch a little bit, and I'm gonna play a little video over the top so you don't gotta just watch them.
Either through the sheriff or a private processor.
And if His Honor may observe that I am allowing you to speak and I'm not cutting you off at all.
Oh, yes, sir, and I appreciate that.
Okay, so I would ask you, if I was trying to get in contact with you, sir, how would I get in contact with you? Without a public conversation, how would I get in contact with you, sir? You
just a second ago, you emailed me, because I'm an Odyssey. But if you wanted to serve me with a lawsuit, there is a procedure that goes. I either accept service at work, which I don't have to do, or you serve me in another location, or you find somebody to serve me. So those are the things you're going to have to end up doing if you choose to do so. But sir, here's the point, okay? And I think we did. I
was actually trying to make a point.
Hold on, Mr. Jones.
No problem.
There's still the issue of service. You have
that's the conversation I'm having with you about is service. Service, refusal of service for first thing. Service being refused.
Well, when we actually have your hearing and you get service, then the refusal of service can certainly be something that can be discussed.
My client, and then when I saw the transcript, usually I say, well, just release the transcript because sunlight disinfects everything, and we'll get to the bottom of it. It's probably not as bad. The cover up is usually worse, but the transcript was pretty bad in my view. So
consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I'd invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts and an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give it.
No, and did nobody say nothing about his ruling? Why are you even trying to throw that in there?
Reverse ruling. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right? I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and in your particular
arise from the same circumstances related to the state's witness.
We're going to get into some more of that later. I just wanted to show a little clip, but this how we all getting there, family. Appreciate y'all for being here. Hit the like, hit the subscribe.
Woody, I did these crimes.
Right?
Shout out to that cartoon over the weekend where somebody used my voice and it was just like
Oh no, the video. Guys, somebody made a video and used AV's voice. It was hilarious reading the transcript.
And Flush of the Gods, shout out, you have a channel as well. Julie Horn has sent me videos. I forget which one it was. It was involving Kayla though, before the transcript came out. And it was great. You were jam-packed with different context in that video that I saw too. So shout out to Julie Horn if you recognize the name. She's the one that recommended you. And thanks for this detail here.
I had to go myself, and luckily he's very loved in our community, and so many members of our team went down there and were there, and so we had a very strong showing of force, but it was definitely something I did not expect to happen. During our hearing, the judge is admitting that he had this ex parte communication, and it seems like that should be what everyone's focused on, not whether or not Brian is going to tell him who told him the judge had this ex parte. It just seemed like deflecting. The judge was in trouble, got caught with having this ex parte hearing, and instead of admit to that and handle that, when Brian brought it up, they're going to throw Brian in jail. It didn't make a lot of sense, but like you said, it's unheard of. These proceedings are supposed to be what we call adversary, where all the defense is there. The defendants, the defense lawyers are all supposed to be present, but instead they chose to have this meeting without inviting any of the defense, without letting them know. And when they brought that up, the lawyer ends up in custody. What we're doing is we are appealing it. So we're filing an emergency appeal. Thank God we have an emergency process in Georgia to appeal contempt orders. We believe the judges of the appellate courts will grant a bond. And so hopefully Brian will not have to spend his weekend in the jail. The worst part though is this trial is continuing.
Oh, waiting. Where's Mr. Melnick? and Mr. Copeland.
Shout out to Ashley Merchant. You hear that? The way he asking for Mr. Melnick and Mr. Copeland, he already knew way early that that was his attorney. They acting like they didn't know. This is before he even came out.
He's waiting. Okay. All right. Okay. Okay. Thank you. Thank you, madam. All right. Anything else, counsels? All right. Take a couple deep breaths this weekend. Take a knee, and come back on Monday and let's get after it again. Okay. All right. We'll see you on Monday morning at 8:30. Okay.
Can you get us the list of names and then any exhibits for Monday?
I think the only I don't know who is being called. We can find out. Ms.love and Ms. Hylton and Mr. Atkins. Who is going to be called? Let's assume that Mr. Copeland invokes again. Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland, and there are certain things that have to take place before we can tell them anything. So
okay,
we have to do that. We have to deal with that and where we are right now.
All right,
and that's just where we are.
Okay, we'll be thinking about.
You hear that, right? Her building blocks was built on Copeland, so without them, they would not be able to go forward. That's the reason why they have to have him testifying.
What scenarios you'd like to have the court look at?
Yes, Your Honor.
Depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Schardt, you can have the floor.
Yes.
And Your Honor, the state has a matter we need to take up ex parte.
Okay. All right.
Structural tool in making assessments of whether or not a particular criminal act is in furtherance of the game. The triangle that is shown is in no way invasive or invading the province of the jury. It simply helps.
Look, she get disrespected sometimes too. Yes, I just had to add that in there.
Thank you, Judge.
All right, ladies and gentlemen, any minister inquiry with me?
Have you reviewed your calendar for July yet? To know any anticipated days off?
No. I live, hour by hour and day by day, okay? At this point.
Well, I never went to law school.
Case, we'll call you when we need you, okay?
Okay.
All right, thank you, sir. Appreciate you.
This just kind of suspicious to me, the way he walk off. What was the point of the cane? I don't know, just a thought.
Without operating under a methodology?
Mr. Menez, what does that have to do with anything? You're supposed to remember, it's a Daubert qualification. This isn't weight sufficiency or before a jury. Your questions are perfectly fine if she gets qualified and we put her in, she testifies in front of a jury.
That's my final question, Your Honor.
All right. You sit down then.
Well, I was waiting for the answer.
What was the question you asked?
Whether she would be comfortable identifying data without using a methodology.
Again, that's another, doesn't really go to her qualifications. That's a weight and sufficiency question.
Okay, I'll take the court's objection, but for the record, it's relevant to her as expert.
Madam, you want to answer that question?
You caught that, right? I'll take the court's objection. Like, why is the court up here talking for the prosecution? The prosecution not objecting. Why the fuck is the court up here talking? He's supposed to be the referee, right?
The question that he asked. Again, can you repeat it? Because
you operate under certain scientific methodologies when you're identifying data, correct?
Yes.
Okay, so it's fair to say you would not be comfortable as a scientist operating without a methodology.
Yes, but we always work under having some sort of methodology, yes.
Okay, thank you. Those are my questions, Your Honor.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular
He said,
reported conversation?
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was
Okay,
having
but-
no interactions with
Okay,
him.
but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this.
Okay, all right, but all of you have kind of, like I said, either unwittingly.
Facts, that tall ass. You know, he been working with the state. That's who pay his check. Still about to do it right here.
Or from, I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they will testify to. So I didn't say you did anything wrong. Okay, but I didn't say you did anything wrong. But
I understand, Your Honor, but I just want to be clear. The only thing that I heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I
don't know of any defense counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. Today, I don't know of anyone that's had conversations with
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer. And that lawyer can make that decision, and so can Mr. Copeland. So I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you, okay? All right.
And they had checked bags. So this wasn't just like something they could easily get him on
Where
the
they just
flight or
walk on,
something.
right.
This was a whole package kind of thing.
And listen, I don't want to gloss over the fact that the demeaning,
What
I mean,
he's
the
saying,
words alone.
The words that he's saying is like, ain't that the pot calling in the kettle black? But talking about some nappy hair. What you got, boo-boo?
I don't know how long. This woman could have been working for
Right,
15
we
hours.
don't know what was said
We don't know,
before.
but even if they were all of those things, it would never justify the way he behaved.
Well,
I'm sorry, it would never justify the way he behaved.
Well,
Walk
there were
away.
a lot of people said exactly what you said once they saw this video, and Young Thug has a message for them.
Y'all so much of hypocrites, and if the bitch in place for playing games, y'all try to bash him, but y'all be the same upload 15 black girls around fighting and trying to kill each other with knives and bats, but try to go to the extreme with the situation I had when the hoe made me miss $150,000 show.
Wow.
Okay. Do you want to have a conversation with him before?
Talk to him right now.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues? Okay, Ms. Weaver, you ready, madam? All right.
Judge, what we have is a non-S service notice that has been filed.
Okay. So, Mr. Jones, you know what non-S means? I'm asking you just not to for any other purpose. Do you understand what that means, though, sir?
To avoid any contention of assumption or presumption, may you please advise me what that would be?
Okay, yeah, okay. What non-S means is that the sheriff went out and attempted to serve the people mentioned in your lawsuit, okay? And he was not able, or she was not able to do that. So usually the sheriff goes out a couple of times, and in varying days, and if they can't serve the person, then this particular entry on the service copy is entered into Odyssey or into the record. So at this point, you've got a couple options. The options are you can ask the sheriff to reserve them if you've got a better address or better circumstances of finding them, or you can hire a private process server to serve the individuals that are mentioned in your lawsuit. So what's your pleasure? Do you want to go ahead and do either one of those?
Mm-hmm. So if I may ask, you in receipt of the communications?
I have, there's a lot of stuff you filed, but sir, I haven't specifically dug into all that because I'm looking for a service document to begin with. I have to be able to show their service. That's why I asked Mr. Kearns, do we have anything for service? Once we determine that issue, then I can look at the rest of the documents that you have.
Okay, is Mr. Kearns in receipt of communications?
Mr. Kearns is my staff attorney, okay? He's not the clerk, okay? He's not any of the other parties. He works for me, all right? But that's not the issue in this case. We told you just a second ago, we have a lot of documents. You were kind enough to include us as a service copy on those particular documents you filed. But again, to my original point, would you like to be given an opportunity to see if you can get service on either through the
Real quick, you see how she was looking? This is after Woody pled the fifth. Look at how what's her name, Hylton, shaking, praying. Watch when they zoom in. Watch her face. Watch.
Sheriff or a private processor.
And if His Honor may observe that I am allowing you to speak and I'm not cutting you off at all.
No, yes, sir, and I appreciate that.
Okay, so I would ask you, if I was trying to get in contact with you, sir, how would I get in contact with you? Without a public conversation, how would I get in contact with you, sir?
You just a second ago, you emailed me, because I'm an odyssey.
Right.
But if you wanted to serve me with a lawsuit, there is a procedure that goes. I either accept service at work, which I don't have to do, or you serve me in another location, or you find somebody to serve. So those are the things you're going to have to end up doing if you choose to do so.
Right. So I could possibly email you if I was trying to get in contact with you.
If you want to communicate with me, yes.
Right. Okay.
But that's not service.
Agree. In this capacity here, in this point, I'm not trying to talk about whether I'm serving a person or not. I'm just trying to clear up whether or not you have received my communications. And then be it so that you're saying that if I want to get in contact with you, I can actually email you, or maybe even email your staff attorney.
Here's the thing, though. You have to be very clear about the purpose you're emailing me for, okay? Because I'm the referee. I'm not your counsel, and you have to technically communicate with all parties. So that's the other reason why service is so important, because then there's no problem with ex parte communication. So it's not. So a lot of times it's just that I haven't responded to anything you've sent because it's not properly before me as of yet. But
So in reference to this summons, which was refused by, I'm correct, her name is Grace Ahn, is that correct?
I don't know. I have no idea, sir.
If maybe Mr. Kearns want to take a look at that so we can make it official for the record so that it's not biased for me, but the court can express who is actually refusing service.
We don't know if there's a refusal of service, sir.
I think someone just read the summons where it says at the bottom of the summons, if the court wants me to read what's in the actual Odyssey records, I can.
But sir, here's the point, okay? And I think we did.
I was actually trying to make a point.
Hold on, Mr. Jones.
No problem.
There's still the issue of service. You have
that's the conversation I'm having with you about is service. Service, refusal of service for first thing. Service being refused.
Well, when we actually have your hearing and you get service, then the refusal of service can certainly be something that can be discussed. It doesn't address the service issue. You still have to get service. That is that the parties still have to know that they're being sued.
Yo, this video is from about a year ago. It's actually on his channel, on Judge Glanville YouTube channel. He trying to blow up, y'all.
So I don't disagree. I don't disagree with you about the premise that you're telling me, but I am disagreeing upon you. You have to get service. This case does not say, hey, if you're a successor in interest, you're automatically a party. You still have to get service upon the correct party. So again, to my original question again, I can reset you for 30 days, and that's what I'm going to do at this point in time, and I'm going to let you get service upon the correct party. So, okay. Yours has been non-est. That means it hasn't been served. So that's what I'm talking about in this particular circumstance. You have got to get service. And once you get service upon the proper official or officials, then we can go forward. So I'm going to give you.
So with that being said, now I'm with you.
On the right, we have the state of Georgia. Now, when she grants motions, you see this green line? But here's where it gets scary. Look at the one in the middle, the red one. Motions denied, 83%. So this is interesting. And let me break this down. The motion type is motion for reconsidering or rehearing. Okay, so these are motion analytics, but now we're breaking down the type of motions. So how does this play out? What is the motion type? Motion for reconsideration or rehearing. So that is for her to reconsider something or rehear something. When it comes to those type of motions, it is very likely she's going to say no, because we see 83%. Now it says lower, right? Because let's look at this. What do average judges in Fulton County land at? If they deny something, they land at 77% of this type of motion. What about the state of Georgia? Usually she's more in line with the state of Georgia at 81% denials. Fulton County itself has a 20% grant rate when it comes to this type of motion.
So for those who don't know, if you just tapped in, that's AV. She reading the new judge, Shukura, the one that's taking over the case. This her past stats, and it kind of give you an idea of what may happen, but it still ain't no, it ain't no telling. But it give you a little idea of her history, though. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Much love.
A little bit of interesting discussion, thought experiment that I wanted to show you guys. These are typically filed by defendants. Her grant rate is 62% lower when the defendant is the moving party. Interesting. Look at Fulton County, which has a bigger line, and then you see Georgia. She's on the outside. So Fulton County typically will probably grant these more, and they're a little defendant friendly, right? But interesting. We didn't see it for a filed by the plaintiff, and that's likely because they just don't have the data, the source that I got this from. All right, let's go in a little bit more. So now we are looking at a different type of motion. How is she with motions for summary judgments? Those are usually filed at the beginning of cases. She is pretty friendly with this sort of thing. Her grant rate is 23% higher with this type of motion than the county's average of 48%. So she's looking good here. So that means if somebody wanted to, file a motion for a summary judgment, they're basically saying there's not enough facts sufficient for us to move on with this case. She's actually pretty good with granting those. So if we can predict or see a motion for mistrial, she might actually hear these attorneys out. Not saying that she won't, she has to, right? But she might actually be pretty open to the idea. Fulton County usually is at 44% with these sort of things, and then the state of Georgia is at 42% with these sort of things. So she is actually higher than both the county average and the state average. So this is pretty good. And usually these are filed by the defendant. So look at that. It's 16% higher when the defendant is the moving party. So when a defendant files a motion for summary judgment, there is a likelihood that she might grant it based on these numbers. So very, very interesting. Look at her here. 45% defendant friendly with these. Fulton County average is 38%, state average is 39%. So that's actually a good thing for Thug. Let's keep going. This I don't think is relevant to us, but
like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse. I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you're always talking about how the appellate court...
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you bring...
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. Okay.
Aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you bring...
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that, tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time I've denied the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
There go the stuttering again. Do we ever talk to the prosecution like that, though? Never. Hey, this part was kind of suspect to me, though. Like, all right, like this is right before they first called Woody out, Copeland, right? Then all of a sudden, he calling cops around, calling the officers like, "Come here, let me talk to you in private." The face is going crazy. Look at him try to hide. Look, you can see him over here in the corner though. You can see his jacket over there still. What you think he was telling them? He was telling them to go. I think he was telling them to go tell the media to not record him when we arrest him because he going to jail, and tell them to move the cameras. I think this was the moment. And you ever seen Love laugh? Look, there she go laughing. Look, I ain't never seen her laugh. You know something was going on. She laughing. It got to be something going on. Look at her smiling. You ever seen her smile? Cause she already knew it was about to go down. She already knew like it's about to be a shit show. It's another part that's coming up too, like right here real quick. This was live, right? So as the officers were walking out, how did it just disappear? This is a full clip. I didn't edit this part right here.
Didn't take you anything else I need to take up with you all before
I swear I
Mr.
didn't
Copeland
edit
comes testify as our next witness.
Yes, Your Honor. Two things. First, I don't believe that anyone in defense has a copy of the immunity, the order granting immunity. I believe that we're entitled to that, so we would ask for that. Additionally, Your Honor, we are going to diligently, over the lunch hour, myself and other counsel, look at these state's exhibits. Last week, we discussed that we had some objections, if you recall, and we kind of put a pin in it because the state said that it was just a large amount and they were going to narrow it down what they were admitting or seeking to admit. Well, now we have a PowerPoint. It looks like they redacted some of the things that were going to be our concerns, but I'm just going to ask, I hope Your Honor understands we just received this and we're going to, over lunch, look at the proposed exhibits, and if we have any specific objections after their redactions, we'll bring that to Your Honor's attention, if that's okay.
That's what you told me, so I certainly understand that.
Right. So what happened since that hearing or that discussion was the state did make some redactions, and I think that addressed possibly all of our issues, but at least some of them. But we just received this, so we'll report back to the court whenever Your Honor wants to.
Okay, but remember, our jury's been here since 8:30.
No, I understand that.
So I'd like to kind of go ahead and get started.
Well, if Your Honor wants to go through these one by one, we can. We just literally.
Well, you can do that during lunch. That's fine.
Okay.
But this is I know that you all we should have been working on these prior to that. So, okay.
Yes, we just got this.
Okay, but you had the larger exhibit for the.
And we brought those to your attention last week.
Yeah, I remember.
Okay.
I remember. Okay. All right. All right, Deputy Ham, summon our jurors, please.
Alaska Airlines a couple weeks ago when he shamed those poor women and tried to pay them off. It was just awful. So he was doing some holiday shopping in Atlanta, walking through the Lenox Square Mall, and then suddenly found himself in handcuffs.
I'm sorry for smiling, but the circumstances here are amazing.
So here's what happened. This is a bad coincidence for him, but police got a call for a stolen vehicle at the mall. They went to go check it out. They were walking through the mall looking for a suspect, and one of the officers happened to recognize Young Thug. And
no, they didn't say he's the guy who stole the car.
Had nothing to do. They did not suspect him for the car at all.
They just said, there's a celebrity. There's Young Thug.
There's Young Thug. But one of the officers remembered, wait, I was in court the other day, and he was supposed to be there for a tinted window ticket, and he never showed up, and the judge issued a warrant.
So they checked out the...
Hold on. So the officer that was walking through the mall for a whole nother case just happened to notice that Young Thug was there and that he knew he had a warrant for a tinted window. And for those who've been following the case, you remember the cop came on talking about the tinted window, and then he followed them back to the supposed trap spot, the house they raided. So this was what happened prior to that, and he wasn't even the driver. How you gonna give him a ticket? And he wasn't even a driver. He was in the passenger seat, but y'all saying he got a warrant. And they over here laughing at him like this shit is funny, and this nigga been in jail for 2 years for nothing. Hit the like button, hit the subscribe. Appreciate you, family.
warrant. They checked out the
was still
system,
active.
and guess what? The warrant's active. On that basis, just the curiosity of, oh, that warrant's valid, they arrested him in the mall.
Yeah, while he was doing his holiday shopping. So he gets the cuffs on, and he was arrested, but he had to pay $500 bond. He was out pretty quickly, but.
Is it not the best karma, though? You remember what he did to the flight attendant a couple weeks ago, how rude he was to those two girls? And he just happens to be walking through the mall and gets handcuffs. I think it's great.
It's amazing.
All right. You hear this nigga? I think it's great.
Ms.love or Ms. Hylton, ladies?
Thank you, Your Honor.
You know we gotta have a little love. She's gonna talk for a minute, but just watch what happened here. She on some bullshit, and just watch how biased he is. See how he been treating everybody else, right?
Status, the state that we're in as pretrial. I noticed that and noted it because I wanted to make certain that the record is clear.
I'm gonna fast forward in a minute, but we gotta hear a little bit of it.
We are not at a pretrial status or state. Mr. Steele referenced the fact that he has demanded a constitutional and a statutory speedy trial. And Mr. Steele also referenced the fact that the court promised or guaranteed that his client would receive one, and in fact, the court has upheld that promise and we are in trial. I want the court to take note of the fact that the legislature, in enacting the statute for which Mr. Williams is charged, said that they wanted to make certain that the community is free of intimidation and threats caused by criminal street gangs, understanding that the state has the burden of proving all of the charges alleged in the indictment at trial. We are at a position, however, where we can point to circumstances that reflect that the defendant poses a significant risk of committing additional felonies. These acts that the defendant has committed go very far back. They include acts of intimidation during the time that his brother, Your Honor, I am proffering as an officer of the court.
Yeah, let her finish, please, Mr. Steele.
I apologize for opposing objections.
Well, what's the basis?
It goes against the law for presumption of innocence. This is the charges in the indictment which the court has to presume innocence. It's an improper argument.
I believe it's just her proffer. I understand the legal requirement, and your client is presumed innocent. But I think Ms.love is proffering how Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
She's talking about something from fucking 2010.
That's what Ms.love is referring to.
It is not.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different from trial on the merits.
I understand, but I listened intently, and this is the indictment, and that's what Ms.love just stated.
It's the charging document, but I understand, Mr. Steele, that it's different. The state has the burden. Bond is different than proof at trial. I understand that. Do you have any further objections, sir?
401 and 402 relevant.
All right, I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge.
Facts, ramble. She just get to talk and talk.
As far back as the time when his brother, Mr. Greer, who was before the court earlier this year,
that's the one we saw earlier,
was initially set to be on trial, was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, "Snitch hoes get murked, them and their kids."
Is this Mr. Williams you're referring to?
It is.
No. I did not get that.
Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked, them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. still may present the objection that this is part of the indictment, but I can play the actual video where the defendant proclaims, so.
She always saying somebody else's name, but she got a problem as soon as anybody mention her name, though. She jump up quick. It's going to show later, watch. I had to mute her real quick because she talked too damn much.
Killed, bro. That's from me and YSL.
We at the Ritz. I flew in, game. I said, don't move till I get there.
All right, so I'm going to fast forward real quick. Just showing how long that she get to talk. I'm going to fast forward this while we listen to Wack 100 talk about his situation with Woody real quick. Appreciate y'all being here. Hit the like, hit the subscribe. Tap in, family.
5 deep.
What up, crime? Much love, family.
I got everything with me. I even have some sex, money, murder niggas with me. Y'all know that nigga that was interviewing Hocus? The black nigga? He was with me. He was with me. That's why he said he was with me. Special, I had South Carolina, New York, Atlanta, niggas I had all kind of shit. We walked from the Ritz. Back then it was a Ritz. We walked across the street. I had about 15 niggas in the parking lot. They said, yo, Pee Wee in the parking lot while we was in the building. I said, all right, when we coming out, y'all go grab his little ass, bring him to me. They get him, bring Pee Wee to me. So, Woody, if you in the parking lot waiting on to go.
Real quick, y'all know who Pee Wee is, right? That's the one who got locked up for shooting up Lil Wayne bus. They saying that they ran up on him and grabbed him, and Woody was saying he was there, supposedly.
Why the fuck? Whoa, when we grabbed Pee Wee, we sat right there on the curb. I talked to Pee Wee. Pee Wee, what you on? Wack, man, you know what's going. Yo, get Thug on the phone. He got Thug on the phone. I talked to Thug on that phone. Woo, woo, woo. We discussed what we were going to discuss. I passed the phone.
And one more thing real quick. Everybody talking about Woody is snitching, Woody snitching, but look, why would Wack 100 go online talking about this in the middle of the trial while Woody is on the stand? Like, what's the purpose of that? What is he trying to prove?
On the game. Game hollered at him. The only other piece that was instrumental in this shit came from Chicago. JoJo Capone. This nigga Woody talk about, oh, the call came from Nipsey and I was in the parking lot and whoop. Nigga, you wasn't in no goddamn parking lot. You was in the parking lot, you just go let, get snatched up, brought to us to the curb. Matter of fact, if you probably go check my Instagram or Game be deleting shit. It's the picture of the nigga with us on the curb. I took a picture of the nigga and put it up. So I don't know what that nigga in there just talking and saying shit and all kinds of shit.
Her ass still talking. On fast forward though.
Crazy.
Still talking.
Actually, the same night, 2Ps. I ran into Gangster. Gangster was at the Ritz with the Mary Compton, the female. Is that right? On my mama. Gangster called me yesterday. He said, Wack, I remember when I ran into you in the lobby. I just come home. He was in Atlanta at the Ritz with the Mary Compton when it was a female. That nigga say, Wack, you sure? I said, we be all right, bro.
Why would he be talking about this online while Young Thug is in trial?
For years after that, yeah. So I don't know where he get all this old crazy ass story and all this old shit. The call came from Nipsey and all this old type of shit. Thug was serious. He was serious. I got him on the phone. I said, Thug, what we doing? Wack, man, this ain't how it's supposed to be, man. But he did it. I said, man, listen, man, whatever was said like we can't work it out. Thug, you be in California way too much. Niggas be out here way too much. Pee Wee low ass right here with us. We out here set. He said, yeah, Wack, y'all running around deep like that. I said, nigga, we supposed to. You supposed to be out here with us. Nigga, we got clubs tonight. We got all kind of shit to do all weekend long, bro. We at the Ritz. I said, I need you to get on the phone with Game. Y'all gonna have y'all conversation, clear this shit up. He said, pass the nigga the phone. He talked to Game about 10, 15 minutes. That was it. Talked to Game the next day again, and that was it. So I'm not gonna sit here and say Thug couldn't have said nothing on us. He definitely can, but I'm gonna tell you like this. It was a simple motherfucking conversation with the right people. Pee-wee was just like me. Wack, I'm glad we was able to resolve this shit.
Facts in the chat.
Because this shit wasn't going to stop.
Crime.
It started when Game was in New Orleans. And I think Thug and Wayne was having words. And I think Game got on the mic. Said he had to go to Atlanta. They called me that night. They said, Wack, Game did this, but we got to go to Atlanta.
So can I ask you a couple of clarifications?
See how long she was talking? On fast forward.
Snitch hoes get murked.
Snitch hoes get murked, and then they and their kids get.
That was in 2010 at the time of Quintavious Greer's trial.
Okay.
And the
2010. Are you serious?
Where calls were made.
Is that more recently?
Yes, it
When
is.
was that?
Those were made in 2021.
Any calls or any other things?
Look at her
after
lie.
the
You seen her
commencement
twitch?
of this particular trial? Anything after December of 2022 or into 2023?
As we are still reviewing the calls that we have received, I've not come upon ones from 2023. I can only point with respect to things that have been observed.
This is why they
by
denied his
officers and
bond.
members.
For those who don't know, this talk is one of the reasons. One of the bonds, they denied him 3 times, but this is one of the reasons. It's because of this lie she was saying right here. So facts at Tall Glass.
Of the state's staff, the drug transactions that have occurred.
Do you have interviews with more recently? Some of the things you told me, are those based upon witness interviews that you have indicated that have been held sometime by your office, sometime during 2022
yes.
And 2023?
Yo, shout out to Candace. I appreciate you for tuning in. No, that audio, they didn't play that. This is just a audio I played because I wanted to fast forward because I didn't want to hear her talk forever. So I was listening to Wack 100 snitching, dry snitching real quick. Appreciate y'all for being here. Hit the like, hit the subscribe, tap in.
Yes.
Okay. All right. All right, madam. Anything else?
Copeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Well, are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
All right, this is a famous part, but let's watch what happened after.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please?
Everybody know he plead the fifth. But just watch the attitudes after the shit. They knew they had fucked up.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take them into custody.
Remember Ms.love was laughing and smiling and kikiing? What happened to all that? You seen the way her face was looking now? And they already knew he was going to do that. They knew they fucked up. Representing that right there. You see that sign? That's what they representing. He got recused, so he was the chief judge of that sign you see right there. So what that tell you about the rest of the state? Or the rest of the U.S. for that matter. Appreciate y'all for being
State, do you have any
here.
other witnesses you plan on calling this afternoon? No, Your Honor. Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
Look, he tried to dismiss it real quick.
Would you please entertain a motion for mistrial?
You already
Mr.
knew this
Steele,
was coming.
I'll entertain it right now.
I didn't want to hold the jury, but it'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew.
That's a lie right there. And Ms.love shaking her head, yeah. He talking about it's what I was told. No, nigga, if the prosecution know or have an idea, they supposed to stop it.
And he has count
officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No, so the jurors have heard Kenneth Copeland.
And as well, okay.
I opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving from this trial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms.love.
Your Honor, I'd just like to put some things on the record regarding Mr. Copeland. As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor, I'm just telling the court I am not accepting the proffer.
Your Honor, if I may...
Okay, but counsel gets the proffer, Mr. Steele. I can accept that. So could you sit down? Sit down, sir?
Sit down.
Okay, thank you, sir. All right, Ms.love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court the observations that members
Steele.
of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak.
All right, anything else I need to take up with you all? I'm going to recess in place to allow Mr. Melnick to finish talking with Mr. Copeland and find out if he or somebody else instead is going to be here on Monday. And but if not, we will be here on Monday at 8:30.
So this is when Mr. Steele, Attorney Steele, he about to lose it right here. This when he about to blow his top. When he got tired of all the shit, he got tired of putting up with it. But I'm going to play the whole thing, not just the little clips that everybody been seeing. So let's get into it real quick. Not the whole thing, but the whole piece. Let's get into it, family. Appreciate y'all for being here. Hit the like, hit the subscribe.
Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received
what's the point?
Something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file.
To be able to play
to be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it.
Trying to move the goalposts.
We were provided last night a thumb drive.
Trying to point at them because they fucking up.
Cut and pasted file names up under headings. With some additional, we were provided last night a thumb drive with cut and pasted file names up under headings. With some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what, and if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Ms.love calls me that I did not do something.
Here we
They have
go.
the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8. After 8 last night, I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Ms.love, I would.
Your Honor, could we strike the hominem attack? Could we strike that?
Okay, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm
Both
not.
of
Please be seated.
You have to do something. You have.
See how she jump up as soon as somebody say her name? But she can sit there and talk all day. And then he talk about both of you sit down.
Threaten me with contempt. You threaten me with jail.
Okay, everybody, calm down. Everybody, both of you, please be seated.
Judge, I'm not.
Both of you, please be seated.
You have to do something. You have threatened me with contempt. You threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Ms.love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the case.
Mr. Steele.
I asked you, please.
Mr. Steele.
How would you feel if you were being treated
Mr.
like
Steele.
this?
Mr. Steele.
I'd like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Ms.love. And that's fine. I like that. But, Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, but they're... And Mr. Williams, to me, this is an innocent man. You talk about, Ms.love said there's a man in the...
Facts. They always trying to block the record. That's exactly what they doing. That's why they keep cutting them off. Appreciate y'all for being here. Hit the like, hit the subscribe. Tap in, family.
Fulton County Jail shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything. This is an innocent man. You talk about, Ms.love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Ms.love has tried to demonize me. At times, Mr. Adams. At times, Mr. Schardt. Now it's all because she wants to win the case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case.
There you go, Tall Glass. You just said that. Facts. It's not even the law. I don't have to give them shit.
It's going to take a long time. Give law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by this way, to the state. October of 2023. October 2023, that was uploaded. Given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have, and now there's a false allegation of misconduct. And what I'm telling the court is what I said again. I do not appreciate it, and you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Ms.love's
false representation.
Your Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I object.
Try to silence me. Will not be silenced.
But Mr. Steele, here's the thing. Okay, I think that Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated.
See how she cut him off?
Please be seated,
and gave him a chance to get in there?
Please be seated.
Whatever you do is fine, but I care about Jeffrey Wood.
He ain't done, no.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial. And so not only for the purposes of this, but it sends not the message I think you want it to send. All right. So I'm going to leave you all to your wise discretion in order to do that. But, I'll take up whatever I need to take up as I see fit. But I know that you all, this has been a long trial. It's very demanding, exacting, and grating on and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see and kind of look at and just remember that you do represent of who you represent and what you're here for. In terms of the tape or the phone calls from Fayette County, it's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's.
But why is he still talking to the defense? Why is he not talking to Ms.love about all that bullshit she just said and all them false accusations she been making for this whole damn case? Why do he just let her get away with that shit? How? Well, I guess that's why you're recused, right? Appreciate y'all for being here, family.
But, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms.love is in her argument is saying that she is, when it's stripped down, less all the sound and fury. She's saying that particular type of file has other things with it. I don't think you were given those, and that's what she's trying to get. So I'm in no way blaming anybody in this particular circumstance, but if you want that particular file, and I think you all should have that the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take that up. And it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other.
I see Miss Hylton down there praying.
Back. And remember,
praying that shit get better, right?
Y'all gonna see each other over and over and over again, and it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I just told you. All right. So I'm just going to recess and we'll see where Mr. Melnick is at that point in time, and then I can talk about Monday for certain. Okay. All right. Okay. I'm just going to recess in place. All right. No. Why didn't you, as an officer of this court, tell me? And that's not what the point is. The point is, you as an advocate, is you should have told me. I got a problem with you now. I would suggest you don't say any more. Now you want to have it both ways. You can't do it. Both sides have an equal responsibility under the rules. It's a professional responsibility. All right, have a seat, sir. Thank you. How fast things have changed. How fast things have changed. How fast things have changed.
Now I see you running, coming from a come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma.
Shout out to Tall Glass.
Now you understand.
Shout out to Champ, my black is golden. Shout out to Tonic Limitless.
All right.
Anybody else have any other issues as to?
Shout out to Damien.
Fulton County has no problem coming in here and cuffing all
Shout
of us,
out to
okay?
Bam.
Don't be an idiot.
How you trying to tell me about myself? You homeless,
Shout out to
Ern. You don't even have a
Candace
mirror to look at yourself.
Appreciate y'all for being here, family.
Here. So I know you all about your principles. But can we just please just listen
Shout
to
out to
Ern
Reggie
so we can
Righteous
get
for
out
the
of here?
beats.
It's 4 cops on the other side of that door. You know if they come in here, they're gonna get your ass on a whole lot of other shit.
You lying ass bitch.
I
knew it. I hate you. Don't you never come back to my house no more.
I hope they blow your motherfucking ass to smithereens.
You better hope they do, bitch. You better hope they do.
This nigga kidnapped me.
I think I'm entitled. You want answers? I want the truth. You can't handle the truth. What are you, fucking nuts?
You thought?
Oh.
What was that? That was a warning, huh? What was that?